SJC-12225, Commonwealth v. Dashim L. Du.
Mr. Schnipper, good morning.
Good morning, Chief Justice Gantz. May it please the court, I'm Merritt Schnipper for Dashim Du. The defendant in this case has never been identified as the robber at issue through a non-suggestive procedure. Instead, he was subjected only to two highly suggestive identification procedures. The first, an out-of-court post-incident show-up, where police added to the inherent suggestiveness of the procedure by draping a jacket that was found near him over his shoulders before they brought him out to be viewed by the witness.
Counsel, did the motion judge find that it was highly suggestive?
The motion judge did not find that it was highly suggestive.
Did he find it was permissible?
He blessed it. He did not suppress the identification, but obviously our position is that he was in error there.
Okay.
The second time was obviously a in-court show-up identification in which Mr. Karadaki, the victim of the robbery here, identified the defendant from the witness stand, where he was not wearing the jacket but was wearing a shirt and tie, in the manner that this court has said in both Collins, in Collins, really makes it extremely difficult for a jury to assess the suggestiveness of a prior identification.
So you're just saying no more in-court IDs?
Well, what I'm saying is no more in-court identifications based on suggestive pretrial procedures. What Amicus CPCS and Innocence Project is saying, and the position that I do agree with wholeheartedly, is that this court should certainly not prohibit any more in-court, should not permit any more in-court identifications absent good reason.
I guess what the government would quibble with is your characterization of this as a suggestive when Judge Feely found it wasn't suggestive, there was no due process violation.
Sure. Well, I think there's two aspects here of the suggestiveness. The first is whether it was so impermissibly suggestive that it needed to be subject to the rule of per se exclusion under Article 12, which is my position and I adhere to. The second is whether both the inherent suggestiveness of a pretrial show-up as a basic matter and a particularly suggestive, even if not fully suppressed, identification where police take affirmative action to alter the appearance of a suspect so he or she appears to conform to a witness description and then brings that person out for a show-up identification should then be allowed to be the predicate for an in-court ID.
Assuming that you're wrong on the first issue, just for a moment, are you quibbling with the equivocal or unequivocal nature of the proceeding?
I'm not quibbling with it. I'm taking deep and serious issue with it because the
I appreciate the distinction.
So I think there's a really important distinction to be made between a subjective expression of an unequivocal identification, in other words, only looking at the manner in which it's expressed by the witness, and whether an objective view that takes all facts into consideration says that this is something that deserves to be treated as unequivocal for purposes of an in-court identification. Because what we have in this particular case...
And I guess the issue is, how's a trial judge to know? So a trial judge has a motion to suppress before him or her, makes a ruling and denies the motion to suppress. Now the trial judge turns to whether or not in-court should happen and whether it was unequivocal. So what are the guidelines the trial court judge should apply?
The guidelines that the court should apply and that this court should direct the trial court to apply is that unless there was a non-suggestive procedure that produced that out-of-court identification that was expressed with witness certainty, there should be no in-court show-up allowed absent the good reason described in Collins and
So are you
Creighton.
saying then under that, any show-up would be, you would never be able to have an in-court ID after a show-up?
Never be able to have an in-court ID after a show-up. And the reasons for that, and the reasons that really make a lot of sense, is that you can never really understand to what extent the expression of certainty at a post-incident show-up is the product of the inherent suggestiveness of the procedure. So this court obviously has allowed post-incident show-ups regularly and in relatively strongly suggestive procedures. I list out cases like Figueroa, Phillips, Mias in my brief. All of those feature the classic Klieg lights, the handcuffs, the in the back of the police car. But the way the court has currently set show-up jurisprudence is that, okay, well, that is inherently suggestive. There's a lot to criticize there, but it also is balanced by the immediacy, the witness's recollection is fresh, and the rest. So setting aside the particular actions of the police in this case, if you're going to allow an in-court identification based on that kind of out-of-court identification procedure, what you're going to do is upset the balance that the show-up jurisprudence has struck by allowing the expression of certainty that it creates, which it's never really able, you can never really tell how closely associated that is with the suggestive circumstances, and you're going to allow that to form the foundation of this particularly powerful form of identification evidence that takes place in front of the jury. And the necessary consequence of that is that you're going to privilege sort of the inherent suggestiveness and really validate it by allowing it to give birth to an in-court identification, as opposed to saying, look, we're going to allow evidence of the show-up, but it's also going to be not associated with an in-court identification that validates it. Instead, we're going to allow it to be subject to what this court has always done in terms of, you know, discussion, cross-examination, and argument about how much those suggestive post-incident show-up procedures should be held by the jury to impact the value of that evidence. If you
Can we,
allow...
before you get to the big picture, we're already into the big picture.
We're in there.
Can we just step back from the big picture for a moment about what happens if there's a out-of-court identification procedure that's unnecessarily suggestive, but the government proves by clear and convincing evidence as an independent source what should happen in the in-court? Just put it aside for a moment. I feel like we're racing there, and there's a preliminary question about this particular motion to suppress, and that is that the draping of the jacket issue and whether or not that was unnecessarily suggestive was never raised before Judge Feely. So what we really don't have here is the issue of, was the witness being asked, so identify the person who is wearing the clothes, or identify the person who you saw do it by the clothes they're wearing. And Judge Feely never got to address that issue because it wasn't raised below. I just want to get the micro issue before we get to the macro issue.
Sure, I don't really see that as an independent source issue so much as I see it as and I agree, well, I agree that counsel did not argue the jacket draping issue to Judge Feely. However, Judge Feely did make factual findings that the jacket was not on him when he was apprehended and was placed on his shoulders for the show-up. So this court certainly has the facts in the record to make an independent constitutional judgment about whether that was impermissibly suggested.
Well, but counsel, do we do that if we don't know why the draping was done? If it was because it was cold, if it was to hide the handcuffs, if it was in fact because it was his jacket and he wanted to keep it together with him?
I respectfully suggest that the record is clear that this draping was done to ensure that this defendant resembled the witness identification because the police had independently determined, based on their prior familiarity with him and their separate investigation, that he was the robber and that he was wearing the jacket when he did it, and that the police did that for the purpose of conforming the witness's reaction to what they already believed was the case. And, you know, I think that the facts in the record and the testimony that was undisputed from the two police officers really doesn't leave any question about that. Now, I agree that the judge didn't make findings about that. So the court doesn't have constitutional and findings of law to look at and to review. But there is really very little question, and to the extent that we're moving away from just a strict suppression issue in terms of why, at trial, Officer Abrahamson specifically said, I did this so that he would more closely resemble the robber. So there's no question here that the show-up procedure, setting aside suppression for a second, that the show-up procedure was used to transfer police belief in his guilt to Mr. Karadaki, and that Mr. Karadaki's in-court identification was then repackaged for the jury as sort of a separate, independent identification of this defendant, when in reality, I think we all know that that's not what happened. What happened is that the police already knew a person who had had trouble with the law and similar issues, went straight to his home, rousted him, brought him out for an identification. But they made they impermissibly crossed a boundary when they altered his appearance for purposes of an identification procedure and did so that he would conform to a witness description. I mean, if there is anything to deter in police conduct, it is affirmative alteration of a suspect's appearance so they match a witness description.
I'm trying to sort out how we deal with it, because there are two separate claims with regard to a show-up. One, that it was unnecessary because you could have gotten a photo spread, or you could have gotten a lineup.
Certainly. And
the judge did that, I guess, was addressed, although I can't find the motion in the record. Is there a motion to suppress?
Yes, there is. I neglected to include it in my record, but the Commonwealth included it in its
It
appendix.
is, okay, and it simply says?
It's a boilerplate. It says
It's a
it was
boilerplate.
impermissibly suggested.
And I guess if I were to read the suppression hearing, I would find nothing in which the defendant is saying, Your Honor, even if you were to find
that it was appropriate to do a show-up under these circumstances, the way in which this show-up was done was unnecessarily suggestive.
You will never find that in the record.
Okay,
But
so,
what you-
so what do we do? I mean, let's assume you're right. Let's assume that if that issue had been raised, he would win.
Okay, I'm ready to.
But it's
assume
not
that.
raised. So what do we do?
Well, I mean, if you just say it's not raised and thus we're going to only review for a substantial risk of a miscarriage of justice, you say this is exactly the type of circumstances that standard is reserved for when police take affirmative action to alter the appearance of a suspect for purposes of obtaining an eyewitness identification.
But the problem is, this is not a murder. I guess it's not a problem for the victim. I'm glad it's not a murder case, but it's not 33-8.
No, it's not.
We'd have to find the counsel was ineffective for failing to raise that, and we don't have any record.
Well, it's real. I mean, if you really want to send it back for a hearing, you can. But the standard is the same of ineffectiveness and unpreserved error, right? I mean, that's what my brother has said, review for a substantial risk. And I think the point here is that while counsel did not raise that, I've fully briefed it, the Commonwealth has fully responded, and the factual findings of the motion judge certainly vigorously support the argument that I'm making, which is that when there's a line that can be drawn. And I would point this court to its decision in Priscilla, which of course is a murder case, but there was a jacket lying nearby where the suspect was apprehended. Witnesses were shown that jacket. They said, yeah, that's the jacket the shooter was wearing. There was a separate show up on the street with the defendant as he was found. And then subsequently, independent evidence connected that jacket to him. I mean, there is an acceptable police procedure. I might have taken dispute with it if I was counsel there, but the point here is that when you're going to actually take the affirmative step of sort of what I would call curating a show-up in order to present sort of a person who you want to make match the witness's description, you've crossed a boundary of permissible police conduct. And I think it's really important to note here that while there is some back and forth about, well, were they saying identify the jacket or identify the person by the clothing that he's wearing, you know, at trial when Mr. Karadaki himself is describing his participation in this show-up, and defense counsel says, was the fellow who was standing with him also black? He says it was too dark for me to see black or no black. And then to suggest that this person was looking out the window of a police car, one person whose race he couldn't determine, and the other person whose shape of his eyes and nose he was able to describe, frankly strains belief.
But you know, it doesn't unpack Chief Justice Gantz's question about how we apply substantial risk here. Because if the out-of-court ID should have been suppressed, we never had a hearing as to whether or not there was an independent source, and we're analyzing the substantial risk of the jury hearing about the out-of-court ID, which I'm sure, and you just referenced it, was subject to significant cross-examination at trial. So the Chief Justice Gantz is getting at a serious question of how we unpack this in determining substantial risk.
Okay, well,
I think you understand the question.
I think I do too. So 2 points there. The first is that while there was not a dispute, a contested hearing about the draping issue in terms of suppression, there certainly were factual findings about the fact of the placement of the jacket. The second is that it's really difficult to see in this record what an independent source would have been, because the identification procedure by this witness happened immediately, or 30 minutes after the incident. So the question is, if they had suppressed that, could they have then brought him in for another lineup? I would simply point the court right back to the amicus brief that talks about how repetitive show-up procedures really just poison the well. I mean, here we've already got 2, and if you're going to talk about potentially 3, I mean, you really have your first opportunity, and then then everything else is tainted. So the question is whether, that's why direction from the court is needed in this case, because police need, at the immediate moment of interaction with the suspect, they need to perform correctly so that we don't get bogged down into situations where they've engaged in one suggestive procedure and we're trying to go back and fix it with some later non-suggestive procedure. So,
Is the only problem here the draping?
well, I think that's the
Because I think that there is some question, at least, you know what happened at trial in
Right.
terms of the officer's explanation, but you don't have that at the motion to suppress stage as to what the officer intended by draping the jacket over him.
Well,
Because it was
when he-
December, as I recall.
It was December.
And you were pulling him out of his house to do this. So it's not unusual that you'd put a jacket on him, I would suppose.
I suppose, but I think it's rather worthwhile to note that he didn't say, I asked him if he wanted to put on his jacket, or I offered him the
He
opportunity.
also says in the transcript at that point that it was also that he was covering the handcuffs. You agree with that?
I agree that he said that.
But in any
The jury
event,
heard that.
The jury heard that.
yeah. So, apart from the draping issue, I guess I want to know if there's anything else that you're saying was wrong in terms of the judge's determination that this was not impermissibly suggestive.
Sure. I mean, I think given the fact that you have probable cause to arrest someone, you're 5 minutes away from the police station, the witness is right there, everybody can come right there, you can take a mugshot and do a non-suggestive lineup, do Silva Santiago, the whole bit.
So it's the fact that there's an alternative.
It's not simply that there's an alternative, because I know under this court's law that's not enough to vitiate a permissible show-up. But when you have an alternative and you disregard it in favor of a highly suggestive procedure, and then you move to make that highly suggestive procedure even more suggestive, I think you're getting into crossing the Article 12 boundary.
Do we have any case in which a show-up has been done with the defendant having clothing he was not wearing at the time being added?
I have not found one. I haven't found one outside this jurisdiction either. I do note the Commonwealth cites the Commonwealth versus Sinelli case from 1983 in its brief, and that was a case in which a person was required to shave his beard to participate in a court-supervised lineup. But what I'd say is when you have a judicial supervision of an appearance alteration that's subject to contested hearing before and then in a non-suggestive lineup, you really have an entirely different scenario than when you have police making the off-the-cuff determination of what procedure they're going to use on the street in the moment. And this court specifically said in Commonwealth versus Johnson, the 1995 version, 420 Mass 458, I believe, that the court is not going to delegate to police officers the determination of when it's appropriate to use a more or less suggestive procedure, and I would urge the court.
When is it not the case that the police can't do a photo spread? So you're saying that they had this fellow, they knew who he was, and they could have done a photo spread. Isn't that always the case?
Oh, I don't think so. I mean, let's imagine you're at a place that's even just, a little bit farther from a police station. You have a different facts. I mean, this Officer Abrahamson had less than 5 minutes to get to the site. Mr. Karadaki was right there. They brought him right back to the police station afterwards to give a statement anyway. So everybody's going. Mr. Dew's going to the police station. Mr. Karadaki's going to the police station. Officer Abraham's going to the police station. But, we're not going to the police station to undertake a non-suggestive procedure. We're going to the police station having already performed a highly suggestive procedure and to just continue with the processing of the case.
The problem with, though, is that it extends the stop.
Well, they had probable cause to arrest him. In this case, I mean, it'd be a different situation like in Martin if they didn't have a basis to compel someone to accompany them to the police station. But when they do, you're not extending anything. All you're doing is extending some protective rights to the defendant.
And that'll be the next case you argue that they extended the stop.
You know I will, but but I'm here on this case today, and I really think, I mean, the police crossed a Rubicon when they added to the appearance of the defendant. I really think that's not non-disputable, and I ask you to reverse the defendant's conviction.
Thank you.
Thank you.
Mr. Steinfeld?
Thank you.
Before,
please the court?
before you start, by the way, I do want to commend the quality of briefing by both sides.
Thank you very
in
much,
this
Your Honor.
case. So, okay, now that I've done that.
Now I'm all perplexed. This motion to suppress was flawed by a fundamental failure of proof by the defendant during the hearing. Now, he must show by a preponderance of the evidence that the out-of-court ID was so unnecessarily suggestive and conducive to irreparable mistaken ID that it would violate his right to due process. But there was no evidence at all at the hearing that the victim selected the defendant because he was wearing any particular clothing. He never said he's wearing the same jacket and that's why I have identified him. The only evidence at the hearing was that he identified him because of the shape of his nose, his eyes, and the color of the skin.
Is that what he said at the time of the suppression hearing, or is that what he said at the time of the show-up?
Both.
At the time of the show-up?
No, I'm sorry. He didn't testify at the
I'm sorry.
show-up.
Okay, but I'm sorry.
I can
Let
see
me
the que-
let me rephrase. Is there evidence that at the show-up he explained his reasons for identifying the defendant?
Yes. At the suppression hearing, Officer Abrahamson said that at the time of the show-up, the victim commented about the nose and the eyes and the color of the skin. So there has never been any evidence, other than the fact that he happened to be wearing a jacket that fit the description, that the victim used that as a basis to make his choice. There is just simply no evidence in the record of that, and I think that the point has already been made, but I want to make it again, that the way that Officer Panjwani told the victim before the show-up what to do was, he said, tell me if you can identify the person who robbed you, and if so, then describe his clothing to me. That, to me, makes it very clear that he was not told to look for a particular article of clothing, but to look to see whether he could identify the robber, and then if he could identify the robber by his facial features or by what he saw, then he was to tell the officer, yes, the guy in the dark jacket. So I think that's a very important point that there
If you're devising procedures for police,
yes.
you would never allow them to do that. To have somebody put on clothing which the person observed, and then have the person ask him to identify him by the clothing which he has just put on.
Right, but he did not ask him to identify him by the clothing. He asked him to identify whether or not he saw the robber, and then to convey to the officer which man he selected, and to convey that information to him by describing the clothing. I agree.
So he could have said, you could have said, tell me on the person on the left or the right, as opposed to tell me by what they're wearing, right?
Yes, he absolutely could have done that.
That
but
probably would have been a whole lot better.
Well, preferable, not a whole lot better, I don't think. I agree that there were better ways to do this, but that does not mean that this was impermissibly suggestive. In fact, I don't think it was all that suggestive at all.
Let me ask you something. So suppose you win on that part, and then we get to the second part of the appeal, and there's about 100 cases that say the show-ups are disfavored, but.
But, yes.
Right. And if they are disfavored, what's the need for a subsequent in-court identification after a show-up? Why do we have them?
Well, I think that this court has never suggested that they lack probative value completely, and I don't think that any court has abolished them, saying that they are so.
Oh, no, I'm not saying that show-up should be,
I'm talking about the in-court ID.
Okay, the in-court ID. So what's the need for it?
Well, the need for it is that it has probative value to the jury, and not just because it's been a long part of Massachusetts procedure, but courts around the country, and also those on television.
Where is the social science evidence that 18 months later, the in-court ID appropriately has probative value? I mean, there's a person who saw him only from, the nose up? Correct?
Right, but he did say that
Nose
he was
up,
able to make
7:30 at
distinguishing
night.
features of his
Right, so I
face.
understand, but it means, so basically, he's got a scarf below the nose.
Yep.
So he sees him it's December, so it's 7:30 at night?
Yep.
So it's dark.
It's a little earlier than that, but yeah.
Okay, dark, and he sees him from the nose, he sees the nose, the eyes, the forehead. And it's 18 months later.
Yes, and the skin color.
Okay, and it's appropriate for a jury to give probative weight to the in-court ID under those circumstances?
Well, it absolutely was pursuant to the law in effect at the time of the trial. There was no question that if there was a suggestive but admissible pretrial ID, then an in-court identification came in without further showing by the
Are you
Commonwealth.
referring to Collins?
No, I'm talking about the general rule.
Okay, because, I mean, Collins
Right.
says that you may do an in-court ID only if there is an unequivocal identification after a non-suggestive procedure.
Right. When I say that the identification here was in fact unequivocal, it was not something less than unequivocal, and I think that the fact he said that's the guy. There's no degree of certainty here, by the way. He just said
Okay,
that is the guy. He identified him.
let's assume it is unequivocal.
Right.
It
Right,
is,
that-
it is inherently a suggestive procedure.
Yes. Both
So-
the in-court and the show-up.
Right. So why, I mean, I guess the concern would be if you only allow the show-up to come in, the jury focuses on that.
Yes.
If you allow that and the in-court, the jury then arguably could have their evaluation affected by the certainty of the in-court ID, and the question is that something which is appropriate?
Well,
to
that
do.
certainly is the question for this court to answer, but I would ask that it do so on a prospective basis and to maintain that the law at the time clearly permitted this sort of an in-court identification.
So are you saying that you think that the language in Collins that says that we allow in court when it's unequivocal and non-suggestive, all that case law that says these are just favored and they're suggestive but would make this a suggestive procedure and we should abolish in-court identifications after show-ups?
Well, Collins says we don't answer that question in
Well, I guess
footnote
that's why
8,
we're
and that's
here.
why we're here today, obviously. So I think that the question was, did the judge at trial rule correctly that Collins did not?
I think that, I mean, arguably, Judge Feely applied the law that he applied Creighton and Collins.
Pardon me?
He applied Creighton and Collins.
Yes.
And I'm asking you going forward, is this a good rule or bad rule? What should we do?
I think that the court should not make any substantive changes other than to apply 403 to these circumstances when you have an out-of-court suggestive but admissible procedure and that ends up in an unequivocal identification, that the law should basically be the same, except the judge should ask himself the 403 question, modified slightly as they did in Creighton for prior bad acts, and to have the standard be whether or not the probative value of the in-court ID is outweighed by the danger of undue prejudice, rather than the substantially outweighed. And I think that that's a perfect mechanism, or an adequate mechanism, for the judge at a trial to take into account all of the circumstances to determine whether or not this particular in-court identification is fair or not, and does it give the jury the tools that it needs to assess the validity of the in-court ID. I think here in this case that it is very significant that the lawyer, the defense counsel, as soon as the in-court ID was made, he said, "Judge, can the record also reflect that the defendant is the only black person in the courtroom?" So this jury certainly had no doubt of the high suggestiveness, according to the defendant, of that ID. So in this case, at least...
Was that addressed in closing argument as well?
Yes. Yes, his whole closing argument was he picked him by the clothing, and he picked him because he was the black guy. And actually, the defense counsel reinforced that by making that comment during the in-court ID. So that was the basis of his defense. It was also made in his opening statement as well as in his closing argument. So that was completely before the jury, that the suggestiveness, if any, of the in-court identification could not have been made plainer because of the actions of defense conduct. So
Right,
even if the court...
But I mean, the same argument could be made in Creighton and Collins, is that the defense counsel is always able to argue to the jury, this is suggestive, but I don't
Yes,
think,
and I understand
I
that
don't
this
think any
court-
of the social science supports the view that the jury is not affected by the in-court ID.
I don't have as much social science in my pocket as my opponents, obviously. And this court has credited much of that social science research. And
Counsel,
of course, acknowledge it.
go ahead and answer. I don't mean
No,
to
no, no,
interrupt.
I'm
I'm just curious,
I'm
how much, if any, of that social science research has been subjected to any kind of hearing in the trial courts? Like cross-examination, Dober-Lanigan hearing of sorts on the social science?
Well, I'm not aware. I thought that this court in Gomez had approved it and said that the need for experts, there was no longer any need for experts, but if a defendant wanted to bring in an expert, he was still able to. I'm not familiar with very many, if any, such proceedings under Lanigan to determine that. I thought it was more by, not by fiat, but by this court finding by taking a look at all the social science research and determining when there was a consensus in the appropriate community so that a case-by-case determination was not necessary.
Now, the judge here did not do this 403 analysis that you're saying should be the only way we go forward, right?
Well, I presume that all judges do it, but there was no objection.
And nothing
On
done
that ground.
expressly on that ground.
That's correct. And because the law, as it stood at the time, said that it came in without further showing by the Commonwealth.
Right, no, I'm just
Right.
clarifying that it did
Yes.
not happen expressly
that-
anyway.
Yes, that's correct. So I am suggesting that if this court changes the rule and makes it more difficult for the Commonwealth to elicit an in-court identification following a suggested but admissible pretrial identification, that it then can rely, that can make it part of the law that the judge shall make a determination under 403 whether or not the probative value is outweighed, not substantially outweighed, but outweighed by the danger of undue prejudice.
And you would not, I take it, or would you limit that only to instances where there's been an out-of-court show-up ID as the first identification?
Well, I could see,
Or could there be other kinds of suggestive elements and other sorts of,
well, I think that it probably should apply whenever there's an out-of-court ID that is suggestive in some way. Show-ups make it easy because they are inherently suggestive, so there's no need for a further determination. But for instance, if there is some variation from the Silva-Santiago protocol that could make the out-of-court ID more suggestive but not so suggestive, and I think in that case, the same rule should apply to an in-court ID. I think there should not be that rule only when there is an out-of-court identification that is unequivocal and is the product of a non-suggestive ID, as in Collins, where they went out of their way to say this was the result of a non-suggestive procedure.
Attorney Steinfeld, I'm struggling with how, if you have a suggestive ID, what good is an unequivocal, if you have a suggestive ID procedure, what good is an unequivocal identification by the witness? Because if it's suggestive, if it's a show-up or something like that, you know, the witness is apt to say, yes, that's the person. And now you've got the unequivocal ID that's going to be used. I'm just trying to figure out how, isn't that's a tainted ID? So equivocal, unequivocal, does it really matter?
Well, I think there are taints and then there are taints. I think this court has long admitted show-up identifications. I'm not going to get into the, you know.
I'm not saying, you know, whether you should admit the show-up, but I guess I'm trying to figure out why you would then go on to do an in-court ID.
Well, for the probative value that it has, while keeping in mind that the defense counsel, as in this case, can make a great use of it and can, both by closing argument and by cross-examination, bring out the failures of the in-court ID or the suggestiveness of it.
Counsel, if we came up with a rule that said, if we extended or followed Creighton and Collins and said no in-court ID after an impermissibly suggestive show-up, should a jury then be instructed not to draw an inference from the failure to make an in-court ID?
Yes.
And, Ms. Steinfeld, on the balancing issue, really, the balancing issue of the probative value and unfair or unduly prejudicial, what you're really talking about with the unduly prejudicial are factors that are considered under common law principles.
Yes, that's correct, but applied to
Right.
police orchestrated
Exactly.
IDs.
From Jones and from the later Johnson case.
But basically to morph that onto the case when the police are involved in an ID, yes.
Okay, good. I understand. Thank you.
Okay, thank you.
Thank you very much.